Yes, please.
May we have your Lordship's indulgence to mention a matter, my Lord?
Yes, please.
Item number 10. In fact, 3 writ appeals are there, my Lord. What had happened before the learned single judge, my Lord, all the records were not produced. So what we did, we applied under RTI and those informations has been furnished to us. So what we propose to do, subject to your Lordship's kind permission, we would like to file an additional affidavit to bring on record those, records, my Lord.
You have to make an application under Order 41, Rule 27.
Fine.
Please make an application. And
We'll do that. How about it? We'll do that, my Lord.
you are for the appellant.
I'm for the appellant.
All right, please take down. The respondents are present.
Yes, my Lord, we have informed.
All the respondents. This appeal is mentioned by learned counsel for the appellant. Full stop. Considering the submission made, we grant his client leave to make an application under Order 41, Rule 27 of the Civil Procedure Code. By when you will file the application?
2 weeks' time?
By 24th February. List this appeal along with any application that may be filed on 26th February.
Deeply.
Same order in the connecting also. Yeah, 2 more connecting.
Okay, and by 20, application to be filed by 24th, a copy of the application should be served on the respondents by the said date. On each of the respondents. Similar order in the connected appeal. Similar separate.
Connected happens. Deeply.
Two appeals are there. Two connected appeals. Separate order. Yes, sir.
Item number 1.
Me, please, Your Lordship.
Yes.
Lordship, this matter I'm appearing for the respondents. On the last occasion,
Who's for the appellant?
My Lord, I am appearing for the appellant.
my
Lord,
friend,
this is an appeal against an order passed by the learned single judge, and the power distribution company, my lords, is in appeal. The order is in respect of, my lords, regularization of the services of 2 employees, contractual employees, premised on the fact that way back in 2015, their clan had donated certain lands. And in lieu of that, their services has to be regularized. Lords, neither the offer document or the agreement, neither the patta indicates any such promise by the power distribution.
We will hear out the appeal.
very well, the appeal will have to be heard. It can be
Hear out
admitted,
the appeal. In the meantime, don't take any steps in contempt.
Lordship, naturally.
We admit this appeal from a judgment and order of a learned single judge in exercise of his jurisdiction under Article 226 of the Constitution. In a writ petition. Learned single judge in a writ petition. we propose to hear out the appeal, dispensing with all formalities. No, before that you write, as the respondent. As the respondents are represented in court, we propose to hear out the appeal, dispensing with all formalities. Advocate on record, next, advocate on record for the appellant shall file an informal paper book in this court by 28th February, 28, serving a copy thereof on the advocate on record for the respondents at least 7 days before the date fixed for hearing of the appeal. List the appeal for hearing on 10th March.
Let's.
Pending disposal of the appeal, the respondents shall not take any steps for implementation of the impugned judgment and order or in contempt proceedings.
Obligation.
What is MC?
MC clause is for stay of the order. No orders are
All
required.
right. The MC so and so is accordingly disposed of.
From hearing 1, item number 2 and 3.
My lords had commenced the hearing of this appeal.
Yes.
My lord, in fact, my lord, your lordship might recall
We
that
have filed an application for some additional documents. It's not going to hold up the hearing. Yes, it's on your lordship's record, which sir.
that is something that we are opposing. My lord,
Very well.
the petition filed in 2021. Orders passed, my lord, thereafter, diverse affidavits filed by the state even thereafter. And now, my lord, my learned friends have to, my lord,
My
come
learned
forward.
friends, this is a writ petition. 5 affidavits have been filed by the parties from each side, my lord.
What's called?
My learned friend's primary argument, as he's been arguing, is one of the primary arguments is that he's being hit with a 17 to 25% commission. We have shown in this additional application, our records are showing they're all state records that virtually no commission is being charged at all. It's a very important aspect. So, right or wrong, my lord, I have a right.
That is because of the pendency of the writ petition. Because, my lord, we had raised this contention, my lord, very vigorously.
Very well, my lord. Your lordship will not shut us out. It's an additional application. My lord, if he wants to respond, he's right.
Responding to the application will hold up the
Mr.
hearing.
Banerjee, we are just passing it over for a short while.
Okay.
We'll make a first call of the other
Right.
matters. Yes. Call from item number 4.
Item number 4.
Lordship, this matter is still pending before the Honorable Supreme Court, Lordship. It can come up to 4 weeks.
This writ petition is further adjourned till 10th March. On the self-same ground as mentioned. In our orders dated 14th November 2024 and 10th December 2024.
Item number 5.
But in this matter, my lord, I appear for the Shillong Municipal Board, my lord. I was required to file a report, my lord. Action taken report. I have filed by way of affidavit, my lord. This is regarding the dog shelter, my lord. If your lordships recollect, in terms of your lordship's last order, your lordship has directed the Shillong Municipal Board to take steps with regards to, my lord, the shelter for the stray dogs, my lord. Now, pursuant to that, my lord, we have identified space, my lord, for construction of the dog shelter, and we have issued a tender, my lord, for construction of the dog shelter. And on 23rd of January, my lord, we have allotted the work order, my lord, and we have granted the contractor 30 days, my lord, to complete the shelter, my lord. So, if your lordships grants us more time, my lord, we'll come with further reporting.
Where is the report?
Look, this is affidavit dated 5th of February. We have filed it by way of affidavit.
Just have it. And what about the location of the zoo?
But that the state will have to answer.
The zoo is in Vibhoy district, Your Lordship, and the animals have already been shifted.
To a new location.
Shifted. The zoo has already come up, Your Lordship. The Meghalaya Biological Zoo has already come up in the Reboy district. And the animals have already been shifted except for a pregnant deer, which has recently given birth, and so she could not be shifted. And the birds are still in the Hydro Park, Your Lordship. Because the aviaries, the designs have not yet been approved. We have filed an affidavit in that regard earlier, Your Lordship.
In the shelter where this animal birth control program is being carried out, the stray dogs cannot be housed.
Your Lordship. The Animal Birth Control Center is in Upper Shillong, Your Lordship, and there was a request from the municipal board, but then we have been told that it is not possible to keep the stray dogs in that center. So now they have identified another.
No, your officer has said that the responsibility is with the board, we will do nothing. But why can't, in the meantime, they are constructing it, why can't the stray dogs be kept there?
We have not got any information regarding that, Your Lordship. If Your Lordship can give us some time, we can find out why the dogs could not be kept there, whether there is no space or what is the reason.
In the meantime, let them keep it in the government. No, Yes, please take it. By our order dated 27th November 2024, in a public interest litigation concerning the relocation of the zoo in Shillong and for measures to deal with dog menace, street dog menace in public places. We had expressed our satisfaction with the step taken by the government for shifting the zoo in Shillong to a location about 35 kilometers from the city. Full stop. Only the birds could not be shifted. Stop. They were also likely to be shifted to the new location after construction of a cage-type enclosure. Next, Shillong Municipal Board was directed to file an action taken report. Regarding the measures with regard to construction of a shelter to keep the street dogs. Shillong Municipal Board has filed an affidavit affirmed on 5th February 2025. Next. It appears from this affidavit that the Animal Husbandry and Veterinary Department of the state government has a shelter for dogs and was approached by the municipal board to accommodate the animals captured by them. Also, in response to a letter dated 3rd January 2025 of the board, the director of the department, by his letter dated 16 January 2025, had informed him that the board was given responsibility to provide a shelter and not the state, and that the facility, the above facility was being used for animal birth control program. Paragraph, however, it is very heartening to note that the municipal board had municipal board soon thereafter invited tenders for construction of a dog shelter home comma, has awarded the contract in favor of a party, and that construction of the shelter has started and expected to be completed within the next 30 days. Paragraph. We direct the municipal board to ensure as far as possible that this construction is completed within the above stipulated time, and the stray dogs provided shelter there full stop. In the meantime, the state, through the Animal Husbandry and Veterinary Department, through the Secretary, Animal Husbandry and Veterinary Department, is directed to verify the authenticity of the director's statement that shelter for stray dogs cannot be provided at the
Animal birth control.
shelter of the department, and if it is possible to keep the stray dogs there, shall cooperate with the board so that pending start of operation of the boat shelter, the stray dogs captured by the boat are accommodated in the state's shelter, dog shelter. Paragraph. List this public interest litigation once again on 12th March. Both the municipal board and the state are to file short affidavits to indicate action taken in terms of this order.
Pleasure.
Highly obliged, Lordships.
Item number 6.
Yes.
Lord, we have received a reply from the institute, my lord. You can just give it to you.
Yes, what do you propose to do?
My lord can give us some time so that we can find out which hospital has this facility, my lord. Accordingly, we can propose the name.
My Lord, for Union of India, my Lord, I'm requesting for another 1 week's time for affidavit. My Lord, I've sent the affidavit for signature, but it has not come back from Delhi. 1 week or 10 days time, we want to transfer, we file it. Well, basically, the sum and substance of the affidavit, my instruction, what I have is that there were extensive consultation in fixing
Who's
the.
for the state?
I'm there, Your Lordship. I also need some more time, Your Lordship.
No, you nominate a hospital which will do this test, that's all.
Lordship, let me have instruction.
What else is to be done?
My instruction is that the age limits have been fixed, keeping in mind the biomedical factors, my Lord, social factors.
That is all right.
My Lord.
That you will submit in law.
My Lord.
But which hospital has the facility to say that irrespective of that, it will be safe to conduct this test or to conduct this procedure? That has got nothing to do with your arguments.
As far as I know, Shillong,
I don't think we have.
you have to go to Guwahati or Swati.
Outside of the state.
They do not have the facility. Facility doctor.
They are conducting the procedure in that hospital, Institute of Human Reproduction. And they are saying that we are unable to say whether it is safe or not. We are unable to understand this.
My Lord. It's them they're trying to wash off their hand, my Lord.
They have admitted the patient there.
No, my lord. Patient is here only, Ceylon.
No, but on what basis you have?
She has visited this particular institute, my lord, because they deal with all this, my lord. This is Institute of Human Reproduction. But now they are saying, my lord, they do not have multi-specialty team.
But as far as is a common knowledge, my Lord, they are the best institute in Guwahati.
Private institute.
It's a private institute.
This is too bad. They are admitting patients to do the thing, and they can't say whether it's safe or not. Please take down.
Section 51, it should be below 50 years.
A woman of just over 50. You will say that no, you have to say whether it is safe or not, otherwise it will be stopped. Yes. We'll call them. A woman of just over 50 years of age wants to undergo the procedure under the Assisted Reproductive Technology bracket Regulation Act 2021. Full stop. The Act does not allow such procedure over the age of 50 years. Paragraph. It appears that this woman approached the Institute of Human Reproduction, Guwahati, to undergo the procedure. Full stop. The hospital advised that the procedure was not allowed by the Act, but if the court directed performance, it would do so. Paragraph. This writ was filed challenging that portion of the Act which does not allow a woman of over 50 years of age to avail of this procedure and for directions upon the hospital to carry out the procedure. Paragraph. By our earlier order, we had asked the hospital to form a medical board to tell us whether this procedure could be carried out safely on the writ petitioner. First up, we had asked the Union of India and the state to take instructions in the matter. Paragraph. On the earlier date of hearing, we were told that the institute did not do anything because of some procedural problem they face with regard to service of the order. Paragraph. Today, we are absolutely shocked to read their letter dated 5th February 2025. To the effect that the hospital did not have a multi-speciality, within quotation, multi-speciality team, which is an integral part of the medical board, which is being requested upon. Also, kindly note that we are a health facility which specializes in rendering mother and child services, unquote. No, not unquote. Hence, we would, I'm just marking this, huh? Paragraph. At one point of time, you are telling the patient that get a court order, we will perform the procedure. Full stop. Now you say that you can't even opine. Now you say that you can't form a medical board, which tantamounts to saying that you can't even opine whether the procedure is safe or not. Paragraph. This kind of an attitude cannot be tolerated by the court. The head of the Institute of Human Reproduction is directed to file an affidavit after due consultation with the specialists attached to this hospital, whether this procedure can be performed on the writ petitioner or not, and how safe is the procedure and what are the risks attached to it. Full stop. If no satisfactory answer is required, we shall pass necessary orders restraining this institute to perform any kind of procedure under the Assisted Reproductive Technology Regulation Act 2021. List this writ application. On 20th February. Advocate and record the registry of this court along with the advocate on record for the petitioner will immediately serve a copy of this order on the institute.
Item number 7.
We'll go back. No, you go back now. Hearing other items, you just call them quickly.
Hearing number 2 and 3.
No, not that. 7 to 11 passed over for the day.
My lord, lordship indulgence, can I just submit, my lord? In item number 8, I am appearing, my lord. It is hearing matter.
Yes.
So, shall I wait as your lordship pleases? Or
passed over for the day.
For the day.
Tomorrow it will be taken up because
my lord,
hearing matter is specially.
My lord, I problem Guwahati, some difficulty tomorrow. Can it be the first week of March, my lord? Some difficulty will be there.
Who's on the other side?
My lord, my friend. Any date in the month of March.
You choose a date.
My lord. 17th of March. First week. There is no first week. I'm out of station. What time is the Manipur? I'm going to go to Manipur. My lord. He has got TG on the 4th. 17th, my lord. 17th March.
All right. By consent of learned counsel for the parties, the hearing of this matter is fixed on 17th March.
My lord.
As far as item number 11, my lord, I have a similar query. Instead of tomorrow, it will be taken after a week or 10 days.
Who's on the other side?
I'm informed.
Choose a date. Any date.
24th or 25th
February. 24th February. By consent, same order. Much. All right.
Yes. My lord, similar prayer in item 9, my lord. Anytime first week of March, my lord.
Well, you're all leaving Shillong tomorrow or what?
No, I'm just not prepared for this matter.
When?
First week of March, my lord.
You're on the other side.
Lordship, yes. I am not.
All right, 5th March.
Deeply.
On your my lordship.
It's called the passed over.
Please, your lordship. Lordship, I beg to make a mention of item number 7, my lord. My lord, I believe the matter can come after 2 weeks, my lord. It's a joint request, my lord.
Yes.
Give the date. When?
Lordship.
24th.
Yes, lordship.
25th February.
You believe, lordship.
Yes.
Item number 2 and 3.
Yes, Mr. Chairman.
Yes, my lord. Lord, this is, my lord, of course, without prejudice to the application that Mr. Banerjee says he is filing. I shall reserve my comments on that. But of course, my lord, the issue that he raises, I don't think is very fundamental to the dispute that is before your lordship now. My lord, the writ petition.
My learned friend is saying he is not making a fuss about the enormous margin which is exploiting him and all the rest of it is giving it up, then I'm absolutely...
No. Why should I give? That is only a part of, my lord, the entirety of my argument.
That part. I'm concerned with that part. Only that.
Well, that is a very small part of the whole.
How much small, very small part.
Well, Lord, your lordship might recall that this writ petition, my lord, challenges 2 amendments. Well, Lord, one is to the Meghalaya Excise rules and the other is to the Meghalaya Bonded Warehouse rules. Now, my lord, the Meghalaya Excise Act and, my lord, the rules framed thereunder, they, my lord, govern the importation of, my lord, foreign liquor, Indian-made foreign liquor into the state. Now, my lord, there is a distinction between, my lord, Indian-made foreign liquor and country liquor. Both fall under the heading liquor, but there is a, my lord, clear distinction between what is known as country liquor and what is known as Indian-made foreign liquor. Now, my lord, country liquor does not really have to be imported from out of the state, but, my lord, Indian-made foreign liquor has, my lord, bottlers and distillers who have their bottling and distilling plants both within the state, but mainly outside the state. Well, lord, big manufacturers, big players, my lord, are outside the state. Now, my lord, so far as this is concerned, previously, the route to market was this. My lord, there would be, my lord, the bottlers and distillers.
Yes.
My lord, they would be placed with indents from, my lord, bonded warehouses. Now, my lord, the excise rules and the bonded warehouse rules permitted the establishment of several bonded warehouses. And I believe there were about 55 bonded warehouses in the state. 45 bonded warehouses in the state. So, my lord, each of these bonded warehouses would place their indents or orders with the bottlers or distillers of their choice, because, my lord, they might want to, my lord, ultimately import certain varieties of, my lord, Indian-made foreign liquor, my lord, kinds of beer, wine, whiskey, and, my lord, other, my lord, foreign liquor brands. And, my lord, that would be imported into the bonded warehouses. And bonded warehouses would ultimately give it to the retailers. Now, my lord, the statute, my lord, said that the bonded warehouses would be entitled to charge a margin of about 8%. So, my lord, this was something that was ultimately grafted into the ultimate retail price. Now, my lord, what would happen is, my lord, the bond price or the bonded warehouse price would be fixed by the government. My lord, let us say, for the sake of argument, that, my lord, the bond price is fixed at 100 rupees for a particular brand. My lord, that would include, my lord, the cost of, my lord, the bottler or distiller. It would include the cost of, my lord, the freight into the bonded warehouse. It would include the bonded warehouse commission charges, which was, my lord, about 8%. And, my lord, thereafter, it would reach the, my lord, retailer, who would thereafter sell it to the consumer. Now, my lord, what happens with these amendments is that suddenly it is decided that we will keep the bonded warehouses, but we will also impose over them a central bonded warehouse, one central bonded warehouse. Now, my lord, when we talk about one central bonded warehouse, the first inquiry is it supposed to perform a function which is different from the function that these bonded warehouses were performing? I will be able to demonstrate to your lordships that, my lord, there is no distinction in the nature of service that they were required to perform. Only thing is, now it says that the central bonded warehouse will be the sole agency or sole point of importation of, my lord, Indian-made foreign liquor from outside the state, and the central bonded warehouse will now distribute to the bonded warehouses, about 45 in number, who will thereafter distribute it to the retailers in the regions, who will thereafter distribute it to the consumers. Now, my lord, without any new or different service being performed, we now have, my lord, imposed on us the central bonded warehouse. And the central bonded warehouse is, my lord, now the sole authority of A, determining what brands of liquor will come in, determining what quantity of what brands of liquor will come in, determining, my lord, how, my lord, they are to be distributed to the bonders or the different bonded warehouses, and there are several other things which we have highlighted, which creates a great deal of concern. And, my lord, these concerns were, my lord, legitimate because, my lord, it is on the apprehension of what might follow that, my lord, the writ petition was filed. The apprehensions were legitimately expressed in correspondence and in affidavits filed before your lordships. And, my lord, the courts have held that yes, this is sufficient prejudice or sufficient apprehension of prejudice, which gives me a locus standi. Now, my lord, so far as this is concerned, now, my lord, here, the apprehensions are, my lord, several. My lord, the entire route to market is disturbed. My lord, when you impose a central bonded warehouse, the question is the central bonded warehouse sets up a separate warehousing facility. Now, my lord, it imports the liquor into the state. It thereafter, my lord, is to charge its own commission, which is only a part of, my lord, my concern. Now, my lord, who bears this commission? That is, my lord, one of the issues. Now, Mr. Banerjee has told your lordship that, my lord, till date, my lord, that is between the years 21 and 24, or, my lord, beginning of 25, my lord, little or no commission has been charged. This is because, my lord, very serious disputes were raised in the writ petition. So, my lord, the fact that, my lord, till now, they have, my lord, really, my lord, withheld the charging of these exorbitant commissions which were proposed, does not in any manner, my lord, detract from the fact that, my lord, in future they might charge these commissions. Because A, the amended rules do not provide as to what would be, my lord, the commission or the basis of determining the commissions. So, my lord, it may be a variable. And it does not also say as to, my lord, how the distribution would work with regard to, my lord, the pricing of the goods and the phasing out of the commissions between the different bonded warehouses. We have on record that after, my lord, this amendment to the rules and the establishment of the central bonded warehouse, which is the respond number 3 before your lordships, they had, my lord, written to the distillers and bottlers saying that we propose to charge 25% commission, which would include 8% for the bonders, which means 17% commission for, my lord, the central bonded warehouse. That was the proposal on record. It is a part of, my lord, the records before your lordships. Now, my lord, that would mean that, my lord, this 17% would ultimately have to be absorbed either by the distillers or the bottlers, which means that, my lord, ultimately their profit comes down, or it would have to be passed on to, my lord, the retailers, which means that, my lord, the cost of the product becomes more expensive.
So this commission which the central bonded house would charge, is fixed by the government or this?
No, there is nothing to say as to what would be the commission. The government only fixes the bond price. Now, my lord, today, let us say the bond price is 100 rupees. That would accommodate within it 8% bonded warehouse commission. But, my lord, if today it is 100 rupees and, my lord, it's to accommodate, my lord, 25% commission, well, in that case, my lord, naturally the cost of, my lord, the sale price either goes up in the hands of the consumer, which, my lord, ultimately affects adversely the demand for the product, or it, my lord, reduces the profitability in the hands of the distiller bottler.
The bond price includes the commission?
Yes, that is, my lord, how it is, my lord, determined. So, my lord, the bond
before also?
Yes, before also. The bond price would be determined by the state, but, my lord, it would include 8% bonded warehouse commission. Now, my lord, the proposal is to, my lord, increase it to 25% just to, my lord, put money into the pockets of the central bonded warehouse. Now, my lord, when the challenge comes, my lord, they have, my lord, not, my lord, gone ahead and imposed the 17% or 25% commission. But, my lord, there is nothing to say that they will not do so once, my lord, this writ petition is disposed of. And, my lord, I dare say, when the matter was heard by your lordships on previous occasions, and orders were passed by the state, my lord, really, my lord, accepting the apprehension of the writ petitioners, at that point, my lord, committee was established by the state. The committee came out with a report with regard to pricing. Then, my lord, the committee said yes, to allay the apprehension that monopolistic practices will be in place and, my lord, this will ultimately skew the route to market or, my lord, disturb the level playing field, we will introduce other central bonded warehouses. completely meaningless. So, my lord, they have really accepted the challenge in the writ petition. And my lord, that is, my lord, available on affidavits filed with the government on, my lord, the records of this court. Now, my lord, coming back to the point, my lord, my challenge, if your lordships will now, my lord, just keeping this background in mind, and have a look at, my lord, the Meghalaya excise rules, my lord, which have been amended. This your lordships will find at page, my lord, 46 of the writ petition.
You're not showing the first one, second one,
I'm second and then the first. Because first the excise rules will have to be amended, then the bonded rate.
Get these scribbling pen of a larger size. Same material, same thing, but large. This is too small. Page?
Well, at page 46, you will see. Well, this is the amendment to the Meghalaya excise rules. Well, it kindly notes the date. The date is 15th October 2020, page 46.
Yes.
Well, this is the amendment to the excise rules. Now, the date of the amendment or the date of this notification, providing for the amendment is 15th October 2020. Well, on the same day, I shall draw your lordship's attention to that. The Meghalaya bonded warehouse rules were also amended. Well, that your lordships will find at page 43. I shall show your lordships both these pages. But my lord, kindly mark that it is on the same day, that is on the 15th of October 2020, that my lord, the Meghalaya bonded warehouse rules and the Meghalaya excise rules are amended. Now, my lord, before I take your lordship through these rules, my lord, I would like to draw, my lord, a very interesting, my lord, fact to your lordship's attention. Now, my lord, here, so far as this is concerned, my lord, this, my lord, notifications were, my lord, on 15th October 2020. Now, my lord, the partnership firm, my lord, one Umpaliu, my lord, company, Umpaliu Central Bonded Warehouse, my lord, which was awarded, my lord, the contract for, my lord, establishing the Central Bonded Warehouse. My lord, that partnership business or that the partnership firm was established on 1st September 2020. My lord, as if in expectation that, my lord, this would come about. So 1st September 2020, this partnership firm is established. 15th October 2020, these notifications are published. The tender is floated immediately thereafter on the 18th of November 2020. So partnership firm September, amendments October, tender November. And, my lord, this partnership firm which is awarded this, my lord, contract to establish the Central Bonded Warehouse, well, that ultimately is comprised of, my lord, partners who own.
Formed on 2nd September.
Well, the partnership firm was 1st September 2020. The amendment notifications of 15th October 2020. The tender is floated on 18th November 2020. The partners of this partnership firm, which are awarded the Central Bonded Warehouse contract, well, they admittedly now, on record, own both, my lord, distilling and bottling plants in the state of Meghalaya and also own bonded warehouses. So, my lord, there is a situation where both upstream and downstream, my lord, manufacture and supply is controlled by the Central Bonded Warehouse. My lord, this is just to show your lordship that, my lord, this was all premeditated and predetermined. Of course, my challenge is independent of this, but my lord, here kindly see, it was therefore the object was not really to my lord subserve any public need or public purpose. It was not really a policy decision which was based on my lord a perception of public need or public purpose. This was really my lord a predetermined move which was my lord ultimately put into effect to my lord ultimately establish this central bonded warehouse for my lord a particular purpose which was my lord which is best known to the state. Now my lord, coming back to my lord the Meghalaya the rules.
You are representing whom?
I am the my lord Association of Distillers and Bottlers. That is the writ petition of your lordship. The Bonded Warehouse Association, my lord, the 45 bonded warehouses have also filed a writ petition. That is the next item in your lordship's list. They have independently challenged my lord these notifications. Now, my lord, after my lord, the statement that I made to your lordship that my lord, the object of establishing or the object of these modifications or amendments to the rules was not really, my lord, salutary. My lord, if your lordships will kindly once again come back to page 46, which is the amendment itself. My lord, kindly have a look at page 46, the amendment to the Meghalaya excise rules. Kindly see, my lord, the second amendment, my lord, that is short title is number 1, serial number 2 is amendment of rule 3. It says, in the principal rules in rule 3, in sub-rule 2 for the words bonded warehouse, the word central bonded warehouse shall be substituted. Then serial number 3, amendment of rule 4, in the principal rules in rule 4, again clause 4 for the word bonded warehouse, the word central bonded warehouse shall be substituted. Then serial number 4, amendment to rule 4A. In the principal rules for the existing rule 4A, the following shall be substituted, namely, central bonded warehouse shall apply for import permit on liquor allowed for canteens, etc. Then kindly let's skip over to the next sentence. About 4 lines from the bottom of this serial number. At the end of every quarter, that is the last day of March, June, September and December of every year, the central bonded warehouse shall pay to the state government the ad valorem on the remaining stock, if any, at the rate applicable for retail license on that day within 15 days. Similar procedure shall be followed by bonded warehouses for liquor meant for canteen license. Well, so therefore, the bonded warehouses remain, the central bonded warehouse is imposed, and they perform similar functions. Now, this becomes very important. Because if you are retaining the bonded warehouses, which are to subserve the similar purpose or the similar need, and you cannot show as to what would be the separate purpose or need that would be subserved by the establishment of the central bonded warehouse, then you are really creating the distinction between persons similarly situated. Persons who are similarly situated to provide similar services for the purpose of importation of liquor into the state. And that will attract the doctrine of arbitrariness in Article 14, which I shall emphasize. So, here your lordship has seen that ultimately bonded warehouses is substituted by central bonded warehouse, and that is how the amendment to the excise rules is brought about. Then kindly have a look at page 43. This is amendment to the bonded warehouse rules. Page 43, my lord, is the amendment. Now, this is, my lord, more significant because this will show your lordship as to how the entire thing is to be, my lord, conducted. Page 43. Now, my lord, this is purportedly done in exercise of powers conferred by Section 36 of, my lord, the Meghalaya Excise Act. I shall, of course, take your lordship through Section 36. My lord, I would also submit that, my lord, the section, my lord, is not ultimately something that desires to make an amendment contrary to the provisions of the statute itself. But, my lord, please have a look at the amendment, clause 2 at page 43.
This should not be there. This is letter pad. Plain.
Clause 2 at page 43. Insertion of new clause Roman 2A in Rule 2. In the principal rules in
Not today. Yes.
in the principal rules, insertion of new clause 2A in the rule 2, in the principal rules in rule 2, after the existing clause Roman 2, the following new clauses shall be inserted. The central bonded warehouse means a licensed central warehouse where IMFL, beer, wine, BIO, etc. imported on prepayment of excise or ad valorem duty, import pass fee or transport pass fee and literage fee are kept for eventual removal to bonded warehouses. Similar bonded warehouses are still in place for effectively the same purpose, as provided for in the Meghalaya bonded warehouse rules, such and such. Then please have a look at the next item, which is 44. Well, after Roman 3, serial number 3, insertion of new rule 44. In the principal rules after the existing rule 43, the following new rule shall be inserted. Now, this is very important. It says, central license for central bonded warehouse shall be granted on the following conditions. A license to establish and work a central bonded warehouse in the designated area on prior approval of the government shall be used by the Commissioner of Excise. 2. Selection for license to establish and work a central bonded warehouse in the state shall be based on competitive bidding process. And kindly see how it throws it open to purportedly throws it open to all. And this is of course to accommodate the partnership which is...
So, Mr. Shah, you tell us this. Among all the factors, everything remains constant except the commission part.
No. The route to market is totally disturbed. That's why kindly allow me to just place this 44 and they shall formulate the point. Here, if your lordship sees 44.2, competitive bidding process open to individuals, partnerships, firms and companies. Then 3 is the base fee is 1 crore 50 lakhs annually. Then 4, kindly see this is very important. The tenure of the license shall be for 10 years. The Commissioner of Excise, however, reserves the right to extend the period of tenure with prior approval of the state government for any additional period after the expiry of term of license at the same or revised terms of the conditions as awarded. So, it is for a protracted term which may be extended. So, this central bonded warehouse and the license granted to this particular CBW is really therefore stay for at least a decade. Thereafter, your lordship will kindly see Roman 7. The central bonded, serial number 7 of 44, the central bonded warehouse must construct a warehouse or godown having a capacity to hold at least 6 lakh cases of IMFL, beer, wine, etc. Then 8. Now, this is where the shoe starts pinching. The central bonded warehouse shall be eligible to supply only to the bonded warehouses located within the state. So, now, we have only one person who is determining the quality, the brand, the quantity, which is to be imported into the state. And it is ultimately the bonded warehouses will have to requisition their supplies from the central bonded warehouse. Then 9, the central bonded warehouses shall have capacity to supply and deliver all the registered brands of IMFL, beer, wine, BIO, etc. to the bonded warehouses within a period of 45 days for goods produced in the state and 60 days for goods imported from outside the state. Now, please, now see, so here we have 60-day waiting period. So, if today a bonded warehouse places an order on the central bonded warehouse, the central bonded warehouse can wait for a period of 60 days to make the delivery. Now, kindly consider the situation. Today, a bonded warehouse comes to the central bonded warehouse and says that I need this particular product. And the central bonded warehouse says that, well, I don't have this particular quality or brand of beer. You take something else which I readily have. Now, the consumer will not wait. The shelves will not be empty. The consumers will not wait to quench their thirst for the particular brand of liquor. So they will take whatever is available. And this immediately impacts the brand, the availability of the brand, and ultimately the consumer choice, which heretofore was determined by the free market and my lord, the open trade practices in the free market. My lord, then your lordship will kindly see, and well, these have been noticed by court. Please see 10. The central bonded warehouse shall have a minimum stock of all types of brands for the 3 months at any point of time. May I pause here for a moment? What is the minimum stock? Not mentioned. How is the minimum stock to be determined? Not mentioned. Who will determine the minimum stock? Not mentioned. Now, my lord, today, if there is no determination of the minimum stock, then my lord, my particular brand, my lord, might, my lord, ultimately only figure, my lord, in a few cases in the central bonded warehouse. And my lord, naturally, when the bonded warehouse comes and says, give me goods immediately, I need it immediately, naturally my product is, my lord, not available. So, my lord, an alternate product takes over. Now, my lord, the question is no basis for determining minimum stock of all types. Now, my lord, it is for 3 months at any point of time. There is no establishment of the basis. How is this to be determined? So, my lord, we are ultimately left to the mercies of the central bonded warehouse, and this is, my lord, a complete, my lord, uncanalized power that is given to it, my lord, to determine as to what would be the minimum, my lord, quantity or minimum stock for 3 months. Now, my lord, this contrasted with, my lord, the next part. At any point of time, well, let me read this. A central bonded warehouse shall have a minimum stock of all types of brands for 3 months at any point in time. Now, this is very important, so that continuous regular supply can be maintained for all bonded warehouses through the state. Now, my lord, how can continuous regular supply be maintained? Well, it says continuous supply be maintained when, well, lord, A, you say that I shall, my lord, wait for 60 days period before delivering the goods to you. B, I don't have any determination for what would constitute minimum stocks for a period of 3 months. So, my lord, here, my lord, again, the question of, my lord,
bonded warehouses have also preferred a petition.
Yes, that's the next matter in your lordship's list. And these matters, my lord, were tagged together for being heard, my lord, along with each other. Then, my lord, kindly see the next thing. The minimum profit margin, please see, my lord, item number 12. The minimum profit margin eligible for bonded warehouses on their sale to retail IMFL off and on licenses shall be 8% for IMFL brands only except bottle in origin. Now, my lord, this is talking about the minimum profit margin for, my lord, bonded warehouses, which was 8% before, which is 8% now. Then kindly see 13. The central bonded warehouse or ex-bond rates of all the imported goods shall be subject to the approval of the Commissioner of Excise during the course of annual registration of brands. So, my lord, what do we have? Well, the minimum, my lord, percentage of commission for the bonded warehouses is 8%. But, my lord,
you can only be affected if your sale has gone down.
Well, I am saying that this is, my lord, how my sale will go down. Well, if this comes into effect, and, my lord, when we talk about prejudice, my lord, apprehended prejudice on legitimate, my lord, expectations of prejudice have been held by your lordships to be, my lord, good grounds to, my lord, approach the writ court. My lord, there are, my lord, of course,
but the other side of the coin is, I don't know what argument they would make, that all the bonded warehouses will form a cartel and only import those liquor from which they can make a windfall profit.
No, my lord, that is, my lord,
shut out the other brands of liquor from the market.
No. My lord, the bonded warehouses, my lord, import all brands. Now, my lord, today, let me see, my lord, we are not allowed to, my lord, openly advertise, my lord, the sale of different brands of liquor. My lord, because it's a regulated item. But, my lord, today, over the course of years, my lord, brand choices have developed. And, my lord, today, that is why, my lord, when a bonded warehouse, my lord, places an order, it is determined by, my lord, the choice of the customer.
Because the bottlers, the distillers, they are not manufacturers.
No, they're manufacturers.
They are manufacturers.
Yes, my lord. Now, my lord, what happens is, my lord, the retailer, therefore, my lord, has a choice. My lord, some prefer Kingfisher, some prefer Bira, some prefer, my lord, Carlsberg.
They are also manufacturing under license, under foreign.
Yes, of course. My lord, all manufacturers have to manufacture under license. Now, my lord, the customer choice is determined, my lord, at the customer level, my lord, who have developed brand preferences or brand fondness. Now, my lord, that reflects into, my lord, their demand, my lord, demand made by the retail stores on the bonded warehouse, which reflects on the demands made by the bonded warehouse on, my lord, the bottlers or manufacturers. Now, my lord, here what is happening is ultimately, my lord, let us say The bonded warehouse approaches the central bonded warehouse saying that I need these certain cases of a particular brand of beer. And the central bonded warehouse, because there is no determination of minimum stock or how it will be determined, and where a period of 60 days is available for supply, they say that I don't have X, I have Y, you take Y. So the demand for X is immediately affected. And this ultimately gives a right to uncanonized power. We have ultimately analyzed all of this in an affidavit which was filed pursuant to direction of state. I shall show you, Lordship, by direction of court.
Article 19 and 21, that is your...
Article 14, 19 and 21, and also, this is ultimately statutory authorised. There are three things that I have ultimately said. This talks about establishment of a monopoly, which is 19(6). There can be monopoly by state. There can be monopoly of state-owned corporation. But there cannot be a monopoly granted to a private player in the market. So my first contention, principal contention is creation of a monopoly which is not permitted. My second contention is that this amendment is ultra-wide as the statute itself. So suffers from the statutory ultra-virus. And my third contention is that because it is without regulation, without checks and balances, and creates uncanalized and untrammeled powers, and also disturbs both the route to market and the level playing field, it violates Article 14. Also creates a difference between persons who are similarly situated. That's the bonded warehouses who perform or were performing similar functions have suddenly been discriminated against and left by the wayside. They have no longer the right to directly approach the manufacturers and bottlers of these foreign liquors. Just to complete this part of it, if you will kindly have a look at here, what I said, PC 12, 44, 12, at page 44, the minimum profit margin of the bonded warehouses is established at 8%. But there is no minimum margin that is fixed for central bonded warehouse. However, that is why, in the correspondence which finds place in the writ petition, your Lordships will find that there was a demand for 25%, which of course they did not give effect to or could not give effect to because of very serious issues that were raised in the course of hearing of the writ petition. And now my learned friend comes and says that we have charged very little commission whatsoever. That is not insurance to say that he will not do so in future. Now here, so far as this is concerned, the last item here, if your Lordship sees, item number 14, on commencement of the central bonded warehouse, the bonded warehouses shall lift all the liquor from the central bonded warehouse against import permits issued by the Commissioner of Excise and cease to import directly from the company's bottling plants, etc. Now, this ultimately talks about the questions of available stocks, margins, period of supply.
But suppose the argument is made that this enactment is for free and fair trading of all kinds of foreign brands available in India.
Well, is it so? Well, that is what we are questioning.
Now, suppose this is just hypothetical.
Yes.
An argument is made that all the bottlers, distillers are together in a cartel. The bonded warehouse owners are also in a cartel. They choose brand X, Y, Z from which they can get the maximum profit and shut out the other brands and say it is not available in the market. Manufacturing is also done in that way. Some manufacture, some shut their manufacturing and eat out of the now suppose how do you meet that argument? Well, this is for now if the demand is for A, B, C brands, it is not available. Now the government wants to ensure that A, B, C up to X, Y, Z brands are available in the market because they have granted to those foreign companies to manufacture and market here.
No, my lord, here what happens is, my lord, when there are many players in the field, but the market forces, my lord, ultimately determine as to what is the demand and supply of the product. Now, my lord, let me, my lord, answer your lordship's, my lord, query. Of course, my lord, this point is not a point raised by my learned friends in the affidavit.
It's not raised, so no. Need not answer. It's just a hypothetical thing which arose in my mind.
Yes, my lord, but except that, my lord, when, my lord, ultimately there are different bonded warehouses in different regions of the state, and they reflect, my lord, the consumer demand through the retailers, my lord, that creates, my lord, that is, my lord, how the market force comes into play to determine, my lord, consumer, my lord, demand, and, my lord, consequently supply into the state. But, my lord, therefore, there is no argument that, my lord, the bonded warehouses have ever in the past attempted to form themselves into such a cartel. On the contrary, my lord, the argument that has been advanced, and, my lord, the court has noticed it in one of its orders passed in this writ petition, is that, look, you have upstream and downstream players both. You have, as partners of the central bonded warehouse, persons who own manufacturing distilling facilities within the state and also own bonded warehouses. So, well, naturally, there will be an inclination to promote their products by either giving them discounts or greater credit periods, or, my lord, ultimately promoting their brands, keeping their brands available at the cost of other brands which may not find place in the shelves in adequate quantities. So, well, that is, my lord, the situation that we are faced with. Now, my lord, so far as this is concerned, now, my lord, if your lordship sees, my lord, the document by which, my lord, I say that, my lord, I was, my lord, really concerned, well, if your lordship sees, my lord, the affidavit filed by the writ petition pursuant to direction of court on the 14th of September 2021. Well, this is an affidavit which, my lord, the court required us to file, my lord, saying that show that what will be the real prejudice that you will suffer. What are your real apprehensions? These are, of course, ultimately captured in the grounds in the writ petition, but this is an affidavit that the court required us to file. And, my lord, this includes, amongst other things, my lord, one letter of the, my lord, central bonded warehouse, which is, my lord, very telling. Insofar as what, my lord, their demand was, and what the future demands might be. Lord, if you'll also kindly see the affidavit filed by the writ petitioners on 14th September 2021. This is a very thin affidavit, but, my lord,
Sit down.
14th September 2021. This is an affidavit affirmed by one Neeta Prannath Kapoor. May I request your lordships to first, my lord, come to page 11 of the affidavit. Now, my lord, this was addressed by, my lord, the central bonded warehouse to, my lord, one of the members of the writ petitioner association, Honor Record India Limited. Well, please have a look at the second and third paragraphs. As per clause 15. As per clause 15 of the license conditions, the CBW has to maintain minimum threshold stock that is in 60 to 90 days. Hence, we now request your company to evaluate the average monthly sales and prepay the requisite ad valorem. Then, well, let's see the next paragraph. We suggest that the cost card should be finalized within 15th April 2021 and should include 25% margin, which includes 8% bond margin, freight, administrative and miscellaneous charges, and CBW margin. Now, initially, or previously, not initially, previously, this 8% bond margin would include, my lord, this bond, the freight, administrative and miscellaneous charges. Now, my lord, we have therefore a 17% demand for commission, which ultimately has to reflect somewhere. Either, my lord, reflect on the profits that, my lord, the manufacturers, bottlers would earn, or, my lord, if it is added to the cost of the consumer, it would reflect on the demand. Now, my lord, this, of course, my learned friends did not ultimately give effect to because of the serious objections that were raised. Now, my lord, coming to the, my lord, various prejudices, which were, my lord, ultimately pointed out to this honorable court by this affidavit, if your lordship see, my lord, page 4 of the affidavit, page 3 of the affidavit. Well, this is, my lord, what is of concern, and this is what has been highlighted. Please see the bottom of page 3. The CBW license creates a monopoly in private hands, and thus the CBW licensee is at liberty to dictate terms of business between the manufacturers or suppliers and itself. Well, this is the first part. Well, now we have highlighted in bullet points what are the principal concerns so far as this is concerned. Please allow me to, my lord, read this. My lord, bullet point, first bullet point under 4, paragraph 4 at page 4. While the impugned amendment rules provide for maintenance of minimum stock of 3 months at any point in time by the CBW license, there is no mechanism to determine 1. What would comprise the minimum of 3 months? 2. Who would decide such minimum stock? 3. In the event of disagreement on the quantum of stock, how would a decision of quantum be arrived at? As such, there is no mechanism for the suppliers to determine the demand and available stocks. Then the second bullet point. In the absence of any of the aforesaid stipulations, CBW licensee would have untrammeled powers to dictate the availability of products irrespective of the demand of the consumers. Then, my lord, the third point. It could now arm twist the manufacturers or the suppliers to agree to their exorbitant demand of margin or trade terms or to sell their products to it at discounted rates, given that it is the only source to access the market in the state of Meghalaya. The fourth bullet point. CBW licensee is at liberty to pick and choose with whom it would transact, and that too on credit basis or cash basis. So, my lord, the terms of transaction is also left to its discretion. Even in the terms of cash and credit, the CBW licensee can arbitrarily impose any credit period on the supplier. For instance, it can purchase goods from a supplier on the basis of a week's credit period. On the other hand, it can impose a credit period of 60 days on a competing supplier. Additionally, given its monopolistic position, the CBW licensee may determine supply payment terms to be paid by the manufacturer suppliers, such as petitioners' member companies, such as funding of excise duty or taxes, transit insurance, freight charges, liability towards breakage, warehousing charges, etc., arbitrarily at its whims and caprices. Now, this is not very important. This is what we had highlighted. Given that the constituents of the CBW have their own manufacturing plants in the state, the CBW licensee can promote the brands of liquor manufactured by its constituents to the detriment of other competing products. And in case of disputes with a particular supplier or a supplier not conceding to the exorbitant terms of the CBW, the market would go dry qua that supplier's demands. And then in paragraph 5, amendment rules do not require CBW license. Well, this total lack of transparency. Amendment rules do not require the CBW licensee to disclose, whether on its website or otherwise, the quantity of stocks imported by it or the quantity of stocks which are currently available with it. This results in lack of transparency in the trade of liquor in the state of Meghalaya, which could be used to the advantage of the CBW licensee and to the disadvantage of the suppliers who do not toe the line of the CBW licensee. It is verily believed that the constituents of the CBW licensee also own and operate certain bonded warehouses in the state of Meghalaya. As such, the CBW licensee can also at its discretion favor its own bonded warehouses over other competing bonded warehouses, which would create imbalances in the geographical distribution of the products and unfairly create pockets of influence within the trade channel. And then, my lord, next item is exorbitant trade margins demanded. That I've already shown your lordship the letter. And, my lord, we have also said, my lord, under this heading, that this additional or increased or exorbitant trade margin will have to be borne either by the consumer, which will adversely impact the demand for the product because it will increase the cost of the product, or it will have to be absorbed by the bottler manufacturer, which will adversely affect their profit margin. Now, my lord, when we identified, my lord, these concerns, my lord, here the state came and filed, my lord, an affidavit. There are two affidavits that were actually filed.
First is affect the cost of the product, And second,
I'm sorry, my lord.
It would adversely affect the cost of the product.
Cost of the product in the hands of the consumer,
Yes.
which would adversely affect the demand for the product. Or it would be ultimately have to be absorbed by the distiller, bottler, or manufacturer, which would adversely affect its profit margins. Now, my lord, once we identified, my lord, these concerns, my lord, the state came forward and filed, my lord, a response. There were two affidavits that were filed by the state initially. My lord, the first affidavit is an affidavit of, my lord, 27th September 2021. I would request your lordships to, my lord, have a look at that affidavit. 27th September 2021, my lord, affidavit filed by the state, which is R1 and R2 in the writ petition.
Where is this affidavit? Wait. Mr. Shah will continue tomorrow.
Yes, please.
How many matters are there in the list?
All finished, sir. All finished. Sir.
Tomorrow.
One minute.
Only one. Sure. Tomorrow is relatives. This one is it.
He's talking to him. For half an hour.
This will be added here. Today's matter. And no more additions tomorrow. All right, please take them. We have heard Mr. Jishnu Shah, Learned Senior Advocate, appearing for the appellate.
Writ petition, my lord.
Please, for the writ petitioner in so and so. Yours is 186.
Yes, yes, ma'am.
186 of 2025. Full stop. He does not conclude his arguments. List all the writ petitions for further hearing as the first matters in the list tomorrow.
I'm very grateful. Very grateful.
You'll be reading the brief because now it's